Senator Morrell.
Thank you, Mr. President. Members, I believe there's some amendments that are being handed out right now. Ladies and gentlemen, this is the bill that deals with, as you are aware, it came to light in the last couple of years that there has been a process through which some district attorneys across the state would incarcerate victims to compel them to testify at trial. So basically, in some instances, if a DA was afraid that a victim may not be available to testify, they would preemptively jail them. And in one case in New Orleans, a woman who was abused by her spouse, she was, for fear of her life, was reluctant to testify. She was jailed leading up to trial, and ultimately she served more time than her abuser ultimately served. It's an abhorrent practice. I've been working diligently with the Louisiana DA's Association. We have had some very difficult conversations, and they have resulted in the amendment that's before you today. This amendment is a work in progress. We're still ironing out a couple other points, but the day is long and the day is short and the work is long. We're still working through this process. This amendment is 90% of what we need. There's a couple of points we're still working on, but the idea being the compromise that in very limited exclusive instances, the option would still be available, but there would be a much more lengthy process where a victim's rights are protected and assured, where every other alternative besides incarceration is exhausted, and more importantly, the transparency piece at the end where we'll be able to track and see how often it's done, and if this process works. And if it doesn't, a future legislature can come back and look at potentially fixing it, but the bill is in a posture right now where the DAs are comfortable with it, with a couple of other minor things we're working on, but for the most part, it's a rare instance in which we all kind of come to some agreement. I see a question.
All right,
Do you want your amendment?
You got an amendment for it?
Yes, I have amendments. I'm sorry. I'd already discussed them.
Amendments sent by Senator Morrell are set number 1708.
All right, Senator Cleary, you got a question on the amendment? Come on down.
Thank you, Mr. President. So, Senator Morrell, I understand some in New Orleans have had a very bad experience with material witness bonds. The position I had, though we sent it out of committee, is that we have to consider that that's an important tool in the prosecutor's toolbox, and I hate that toolbox analogy, and I just used it anyway. But tell me what the amendment does here, and that I'm not looking to get the perpetrator a break. I don't think you're looking to give the perpetrator a break, but what is different about these cases that we need to carve out an exception for them?
Well, I think the difference between, let's say, a mugging and a sexual assault or domestic violence instance is that there are a tremendous amount of other considerations. Typically, the abused person knows or is in a relationship or maybe lives with the aggressor. Historically in this state, we've seen that the state has a very poor track record on trying to reach out to these women and prevent further traumatization. And as you know, as a former prosecutor, just because a prosecutor is ready to prosecute a case doesn't mean the victim's ready to prosecute the offender. And there are many instances in which this process, where a victim has not gotten to a point where they're ready to do this or they struggle with it, when you have someone who's already been traumatized by sexual assault or domestic abuse, and in order to secure a conviction, the district attorney potentially incarcerates them, you're essentially re-traumatizing the victim. Now, to your point, the amendments as they're structured, they still give the DA, in a very limited circumstance when necessary, the ability to use that tool in that toolbox. But what it does is it creates a presumption of we don't do this unless it's the extreme circumstance, versus treating a material witness warrant for a sexual assault victim as the same when you treat for someone who was a witness to a drug deal. Because as you know, with material witness warrants, it's basically anyone who's a witness. And in these instances, I would argue and I would posit that these are different than the guy who witnessed some guy's shifting and selling heroin versus someone who was sexually assaulted by a friend, dating partner, or a spouse.
All right. I don't think I don't know the right way to say this, but as far as there are safeguards in place currently, as far as the DA doesn't just say lock them up, the judge considers the situation before they set a material witness bond. And so they might set a material witness bond at a very low, easy to make number to assure that they come. It's not just let's lock them up. Is that correct?
I don't know if I could agree with that, Mr. Clater, because as you know, when you talk about DA's discretion on how they secure bonds or pursue material witness warrants, it's a tremendous amount of discretion there. So to kind of objectively say, well, they do it in this kind of gentle process, as you know, because you were a prosecutor, material witness warrants are used quite frequently to force people to testify. That's their purpose. And the threat of incarceration, basically with these victims of sexual assault, domestic violence, you put them in a position where in the multiple cases that happened in New Orleans, for example, and I don't want to say I hate using New Orleans, it's the one I'm most familiar with, that's where I'm from, but you create once a community of people. Let's say a great example in New Orleans, a group called Hager House. They do housing for sexual assault victims, domestic violence victims. When you have someone who's gone through a material witness warrant experience and they tell someone, yeah, I reported my husband beat me and he raped me and they put me in jail for 80 days. And that's the narrative on how they treat sexual assault victims. The challenge becomes you might have less people testifying, because if they know that to testify and to come forward means if they are threatened or scared by their abuser and they refuse to testify or they're not there yet, that a prosecutor eager for a prosecution can jail them in a prison. It's not something that I think is appropriate. I think that if you look at the amendments that I've gotten working with the DA's Association, that we preserve the ability to do it while acknowledging that in these circumstances, this should be a last resort. It shouldn't be as easy to obtain a material witness warrants for a sexual assault victim as it is for a guy who watched a drug deal.
And I understand the distinction you're making, and I didn't ask my question or state it very well, but the point I was trying to make, there is a stopgap between the DA and this material witness proceeding, that being the judge that can listen to what's going on. Just because the DA asks them to create a material witness bond, they don't necessarily make it, the judge, something that is insurmountable.
Well, I'll give you a real basic fact. In this bill, it requires that the victim who potentially is facing a material witness warrant has to be notified of a right to counsel. Under the current law for material witness warrant, there is no requirement to tell someone they have a right to counsel. Depending on how you're obtaining it, there's never necessarily a requirement you Mirandize them. So there are additional protections in here that don't currently exist in the law. So I would say that, yes, there's a process, but the process is heavily favored towards the prosecution and the use of a material witness warrant, which is why working with the DA Association, who is now in support of the bill, we've worked out a compromise in these instances in which we deem that as a legislature, as a body, we're going to say these people need to be treated a little differently because of what they're going through. Now, mind you, just so I don't seem inconsistent, it's sexual assault victims of any gender. So I'll make sure I'm being consistent. It's men or women who are sexually assaulted.
All right. And it's a rather lengthy one, and I hadn't had a chance to see the amendment before it came out here, and I certainly trust that you've said you've worked with them. So what does it do in a nutshell?
In a nutshell, it creates kind of a list of alternatives that DAs would go through as alternatives to incarceration, whether it be ankle monitoring through GPS, whether it would be working to find a secure location that the victim would feel comfortable in. It goes through a list of alternatives that one has to go through, and if those alternatives do not work, or if they're impossible, or if you've got a situation where someone may flee in the jurisdiction, that then as a last resort, they would have the ability to begin the process of a material witness warrant. That is so. It does not remove the ability. It simply says that it's a last resort.
All right. So we've progressed from the old days where the victim comes in and says, hey, we've all made up and everything is good. I don't want you to prosecute the case, where the DA would then say, hey, look at this caption. It says State of Louisiana versus Mr. Jones, not you, Miss Jones, or Miss Jones, or partner of Mr. Jones. The state of Louisiana, we're going to prosecute it, and if you're not cooperating, you can sit yourself in jail. So we've learned that that's not the best way to go about it. Is that what you're telling me?
Correct. And I wouldn't so much say that often it's we've made up. It might be a woman who has been previously domestic abused comes in and says, I'm living at home with this person who abused me. We have 2 or 3 minor children together. I'm not in a place where I can comfortably distance myself. I'm not comfortable going forward right now. Or just the trauma of a sexual assault, let's say of a college student, is a point where they just aren't there yet. And the challenge that we're dealing with is trying to balance, obviously, the effort to convict and deal with these reprehensible individuals while making sure that everything was done before we got to that step of possibly putting them in jail. Because right now, under a material witness warrant, that's kind of what's on the table, is putting you in jail. Thank you.
Senator Mizell, you got a question?
Thank you, Mr. President. I'm not a lawyer.
Right.
And my concern with the bill is that trafficking victims sometimes have to be held. And I know it doesn't address that, but my fear is that the final form may not look like what we're seeing today.
And certainly that has been part of the conversation with the DAs as an issue we're working with, but that is part of the reason why the amendments leave it on the table as an option, as a last resort, is because some of the most egregious cases are where you have especially a sexual attraction victim where they might be moved out of the jurisdiction. We had a case that came up in the committee, and this still gives them the ability to get that warrant if necessary. It just means they have to go through these other steps before they do that. So I hear what you're saying, and we are working with the DAs. We're all very cognizant of trying to protect their ability to help women, especially sexual trafficking victims. Because, I mean, we have women that are kidnapped from other countries, for example. That is why rather than the original bill that took it off the table completely, this is a compromise to still have it on the table in limited instances like the ones you're talking about.
And to add to that, sometimes what is a trafficker may look like a dating partner or another relationship. But I would just like your assurance from this point that thought would be maintained throughout the process.
Well, and in the amendments, there's actually a separation. So let's say that you have someone who is being trafficked who's also been sexually assaulted, or someone who was a witness to let's say a witness to a murder who was sexually assaulted. Mm-hmm. The prosecution could pursue a material witness warrant unfettered for the murder. They would only be restricted if they were simply seeking it for only the sexual assault. And that was something the prosecutors were very cognizant of. They said, listen, we need to be able that this person has seen multiple crimes. If someone has just been not just, but if the issue is that they are someone who was a victim of sexual assault and domestic violence, and they're not ready to help or participate in their prosecution is one thing. That third guy there who was trying to help her who got murdered, that's a whole separate thing. And that maintains as a separate thing. Okay? We're on the same page. You're welcome.
Senator Martini.
He waved.
All right. Senator Clayton, you got another question on the bill? All right. Any questions on the amendment? Any objection to adoption of the amendments? All right, they stand adopted. You have further amendments?
I have further amendments by Senator White. Amendments by Senator White is set number 745.
Senator White?
You withdraw them?
He says he never saw this. I can talk about it if you want to bring it up.
No, I don't make him go down and
All right, gentleman withdraws the amendment. Secretary, any further amendments?
I have no further amendment.
All right. On the bill, Senator Clayton, you want to ask him a question on the bill? He waives. Any further discussion on the bill? Senator Morrell, you have a right to close.
Thank you, members, for your time and consideration. I know you're all very cognizant of how complex this issue is. As I stated previously, there's still a couple issues we're working out with the DAs. They've been very good partners on trying to find a compromise on this complex issue. We'll continue to work with them throughout the process, and I'd appreciate your support today. Thank you.
The gentleman move final passage of his bill. When the machines are open, those in favor will vote yes, those opposed no. Senator Milkovich, yes. Vote your machines, please. Senator Chabot, yes. Senator Donahue, yes. Senator Tarver, yes. Senator Fanning, yes. You through voting, close them up, please. 36 yeas, no nays. The bill final passage, reconsider vote on the objection.